Now, I said there was a second case that we're going to contrast here. This is the case of Kowalski versus St. Francis Hospital. Driven to the ER by a friend, an intoxicated man wants to be admitted to a detox facility. So, despite having a blood alcohol content that was off the charts, he's somehow alert and manages to walk without help into the ER, where he's taken to a room and a physician visits with him for a bit and agrees to admit him to the hospital's detox program. The patient sits in the ER for about 4 hours before he finally decides he's waited long enough. He removes his IV, tells the nurse he's out of there. The nurse says, "Wait just a second. Can you just wait for a moment so that I can go let the doctor know?" The patient says, "Okay, I'll wait." The nurse goes to find the doctor. When she returns a few minutes later, she finds the patient is already gone. She rushes back to the doctor and asks if he wants her to call the police. The doctor says, no need. Well, long story short, after walking away from the hospital without an escort, the patient is struck by a car less than 2 hours later and severely injured. Kowalski sues the hospital and the physician. His attorney argues that because Kowalski was drunk, the doctor had a responsibility to protect him from himself. The court ruled that the physician had no right to hold Kowalski against his will. But wait a minute, you say. How can that be? The guy was admittedly drunk, had a high blood alcohol content. We know this. Wouldn't that be enough to justify holding him involuntarily? At least until he sobered up? But the court says no. You don't have the right to hold him against his will. So let's break this down. You have a suicidal patient that escapes an ambulance and dies. In that case, the EMT is found liable, grossly negligent. On the other hand, you have a drunk patient leaving the ER, AMA, gets struck by a car. The physician is not liable. The court says he had no authority to hold the patient against his will.
Really?
As an EMS educator, I have spent years teaching people a very simple philosophy that prevention is always better than crisis management. In other words, when it comes to preparing for the worst case scenario, it's better to be proactive rather than reactive. Do everything you can to prevent the zombie apocalypse before it starts. So think of it like this. When's the best time to buy a fire extinguisher? Before the fire starts.
Well, duh.
I bring all of this up to say, how can you win at a game when you don't know the rules? How do you avoid breaking rules that you don't even know exist? The time to know the law is before you have an opportunity to break it. So without consulting Google, can you quote the Fourth Amendment? How much can you tell me about the 14th Amendment? What about USC 42, Section 9501? What about Terry versus Ohio? A landmark decision that has an impact on the 14th Amendment and is relevant for us. I'm sure you're aware of that case. If you have no clue what I'm talking about right now, don't feel bad because you're in good company. Most EMS providers are never taught anything about these issues, and yet they have a direct impact on the legality of our use of involuntary transport and patient restraint. So let's take a look here at these. This is the Fourth Amendment, and I want you to really pay attention to the words that I have underlined and read. A person has the right to be secure in their person against seizure. When you take someone involuntarily to the hospital, you have in fact made a seizure of a person. That's the law. You don't even have to lay a hand on someone for this to be the case. All you have to do is by means of physical force or by show of authority in some way restrain the liberty of a citizen. In other words, if a reasonable person would not feel free to terminate their encounter with you at any time of their choosing and walk away, what you're doing could qualify as a seizure. You're going to love this. Have you ever heard a police officer say to someone, "You can either go to the hospital with EMS or go to jail with me"? Let's call this phrase exactly what it is. It's a threat. It reminds me of that scene in RoboCop where he says to the bad guy,
"Dead or alive, you are coming with me."
no matter what the dude says, he really doesn't have a choice. His opinion doesn't actually count. Even if he says, okay, I'll go. Is he really voluntary? I think he's probably more voluntold. And legally, that places us on thin ice when we're doing it in the context of an involuntary transport. Likewise, just threatening a patient with the use of restraints is enough to qualify as false imprisonment. If you say to a patient, if you don't behave, I'm going to put you in restraints. That's a bad idea if you don't actually have true justification for going ahead and using those restraints. If you feel justified in threatening the use of restraints, you probably have plenty of reason just to go ahead and do it. The second reason for avoiding that infamous phrase is a small matter of scene security.
I wonder why.
How do most people respond to ultimatums? How about you? Do you feel all warm and fuzzy when someone gives you an ultimatum? Or do you start to feel kind of like Bruce Banner does before his skin turns green? Throwing threats into a situation that's already filled with volatile emotions is tantamount to throwing gasoline on a fire.
Not a great plan.
Probably not going to make things any better, but it could make things a whole lot worse. To me, at least, that seems like a very unwise thing to do just before you're sealed up in the back of the ambulance with this guy. If a patient has done something bad enough to truly make jail his only other alternative, he probably doesn't belong in the back of your ambulance to begin with.
That was good advice.
Just some food for thought. But let's think about this. When you utter a phrase like that, you can either go to the hospital or go to jail. Does the patient at that point feel free to leave at any time he wants? Probably not. So, by show of authority, could that constitute a seizure? Yes. But let's say you do have a valid reason for transporting a patient to the hospital against his will. You're not quite out of the woods yet. A lawful seizure can quickly become illegal if it is carried out in what the law refers to as an extraordinary manner. Now, what we mean by that is that you make this seizure, which might otherwise be lawful, but you do it in a way that is unreasonable. For example, in Wyoming a few years back, some paramedics found themselves in hot water after forcing a suicidal patient to go to the hospital against her will. The decision to take this suicidal patient to the hospital involuntarily was not the problem. It was the manner in which they took her, carrying her to the ambulance naked and handcuffed for all of her neighbors to see. That was a big problem, and it ended up being seen as a Fourth Amendment violation. The most commonly alleged violations of a patient's civil rights involving EMS are those that involve the Due Process Clause of the 14th Amendment, which guarantees that the government will not deprive a person of life, liberty, or property without due process. Now, this brings me to a very difficult to accept point for EMS providers, and that is that oftentimes we may believe wholeheartedly that involuntarily taking and treating a patient is in that patient's best interest. If that patient is of sound mind and we take away his or her freedom without lawful justification, it's false imprisonment. Just like the Fourth Amendment, you don't actually have to apply physical restraints to be guilty of false imprisonment. The threat alone is enough. And while it's true that criminal charges against a provider for false imprisonment are pretty uncommon, very rare, civil suits for false imprisonment are much more common. And as if that wasn't enough reason to know the laws governing restraint and involuntary transport, consider this. If you restrain a competent patient without just cause, the second you make physical contact, you've just committed battery. Deprivation of a person's liberty is always a serious matter. So I want you to think about this question. If medical control authorizes an involuntary transport or the use of physical or chemical restraint, all liability is then transferred to the physician and EMS is protected. You know, we've heard this before, that we are the eyes and ears and hands of the medical control physician. So if they tell us to do something, we're just acting on their behalf. And if we do something wrong that they told us to do, they're the one that gets sued, and medical control just saved us, right? Wrong. The truth is that if you do something that violates a patient's civil rights, or you do something that is grossly negligent, it does not matter who told you to do it. It will not be your get out of jail free card. So the question then becomes, why bother calling medical control? Well, it's still a good practice in these cases because it can serve to show good faith. Think of it as doing your due diligence. It's kind of like a family doctor who decides to call a specialist for a consult on a difficult case. Calling medical control is very much similar. It's showing that you sought an expert's opinion because you want another perspective, just in case you've overlooked something. It's also like performing the medication administration cross-check with your partner before administering a drug. You have two sets of eyes on the situation. Maybe your partner or medical control catches something that you overlooked and saves you from making a mistake. You document the consultation, showing you went the extra mile to ensure you were delivering the best patient care you could. That is acting in good faith. So it's still a good idea to contact medical control when you have a difficult situation unfolding before you, but do not perceive medical control as being your get out of jail free card. If you're doing something that violates the patient's civil rights or is grossly negligent, it's on you.